The new presidential proclamation that conditions entry of H-1B workers on a $100,000 payment represents one of the most dramatic interventions in the United States' high-skilled immigration system in decades. For knowledge workers, faculty, researchers, engineers, physicians, and specialists, the rule introduces a barrier that is both financial and operational. Unlike prior adjustments to filing fees, which amounted to a few $1,000s, this measure creates a six-figure hurdle before an H-1B holder can even enter the country. The impact goes far beyond cost. It reshapes mobility, hiring pipelines, and the global reputation of the United States as a knowledge economy destination. In universities and research institutions, the implications are immediate. Many professors, postdoctoral scholars, and clinicians are recruited internationally. A requirement to pay $100,000 for each entry will force institutions to suspend or cancel hires, freeze international travel, and scramble for national interest exceptions. Departments already struggling with budgets will not be able to redirect millions of dollars toward entry fees without cutting back on salaries, course offerings, or research funding. For students, this translates into fewer available courses and diminished research mentorship opportunities. For corporations, the disruption is just as serious. Technology firms, engineering firms, and healthcare organizations that rely on H-1B talent will need to rethink their workforce strategies. In practice, the new condition makes it extremely difficult to bring in new international hires or allow current employees to travel abroad without risk. While larger firms may attempt to budget around the fee in rare critical cases, most companies will avoid payment altogether, resulting in cancelled projects and staffing shortages. The innovation pipeline, already highly globalized, will narrow. Another layer of complexity comes from legal uncertainty. While the text of the proclamation does not specify whether the payment is annual or one-time, major news outlets have framed it as an annual cost. If enforced annually, the barrier is absolute for most knowledge institutions. $30 million for a major research university employing 300 H-1Bs, or similar multiples for large corporations. Even if treated as a one-time entry fee, the expense is still untenable at scale. Litigation is expected, but until courts intervene, employers and workers face a paralyzing level of risk. The wage-based justification behind the policy does not align with actual outcomes. In both higher education and industry, budgets are relatively fixed. Introducing a $100,000 entry payment forces institutions to reduce salaries or headcount, not raise them. This means the policy undermines the stated goal of incentivizing higher wages for U.S. workers. Instead, it creates staffing shortages, pushes research and development abroad, and discourages top international talent from pursuing U.S. opportunities. Knowledge workers themselves, are facing an environment of real instability. H-1B employees are advised to avoid travel, just in case they end up stranded abroad. New hires might see their offers delayed or even rescinded, and current staff have to weigh personal and professional risks when thinking about attending international conferences, doing research fieldwork, or simply visiting family. The United States, which has long been seen as a magnet for the world's best scholars and innovators, now risks a reputational hit that could honestly speed up the outflow of talent to places like Canada, Europe, or Asia. Ultimately, the $100,000 fee acts less like an immigration filing adjustment and more like a barrier to entry into the United States knowledge economy. If it's implemented without widespread exemptions, it will, in effect, cut off essential streams of international expertise in teaching, research, healthcare, and technology. The practical outcome here isn't better wages for Americans, but rather diminished institutional capacity, disrupted global collaboration, and weakened United States competitiveness. For universities, corporations, and the knowledge workers themselves, the most urgent step is really collective advocacy for broad national interest exceptions or judicial relief that can prevent this policy from undermining critical national interests.